Hello, everyone. Welcome to Uncivil Law. So the Sean Diddy Combs Puff Daddy P Diddy trial, which is currently underway in New York, has a bit of a interesting turn, as the jury has asked the question in the explicit fashion that the Karen Reed jury never quite asked. But this jury asked the question in the explicit fashion. They said, "We have verdicts as to counts 2, 3, 4, and 5, but are hung on count 1. What do you want us to do?" And this is brand new information that is just coming down. So we don't have the answer yet as to what the court wants to do here in terms of this. So we're going to try to watch some of this and see what's going on, because it's exciting, right? It's exciting. Maybe we'll get some partial verdicts. We'll see what's going on. Who knows? We'll catch up. So let me we're just gonna kind of do this. Just happened, so I have to get like things set up on my end a little bit. But yeah, just give me 1 second, and we'll listen to some long crime as we try to figure out what are we gonna do. What are we gonna do? How are we gonna solve this problem? All right, let's go.
Another question. This is from Archie and Lilybet. The question is, this is such a complicated trial. Do you think the jury will fully understand everything that they are voting on? And Philip, I'm going to toss this one to you. It is confusing. I mean, even for someone like me who's been researching this case for quite some time, the jury instructions were very thorough, but it still can be confusing. Do you think it's at all possible that jurors are confused?
Were to give those same instructions to a room full of judges and lawyers, they'd all be scratching their head in a confounding manner. They wouldn't know how to read them as well or to interpret them. But they have the benefit of having been in that jury room this long to really read through them, try to digest them, and truly understand them. And if they don't, they'll ask the court a question. And in fact, wasn't there already a question about distribution? So one of the words they got hung up on, and they
so this jury has been asking questions apparently about some of the charges and some sub charges. So apparently this jury has been a little bit more active apparently than most juries in asking questions. They're like asking questions more freely. So they were asking questions relating to some of the sub charges or something. So, and presumably what the court did is just simply read back the instructions as they were given the first time, because that's really all they can do. But yeah, so we'll see what's going on.
In terms of one word, leave the resort and have to proceed.
Unable to follow directions. They keep those notes. We already instructed, and update Nicola goes forward and returns and hands Sean Combs the piece of paper. And what does he do? He stares at it. House behind me. And I've got another question for you. I did not pay for it. Now this says to Adante.
So I'd imagine P. Diddy staring at him and thing for the court on other charges. And now that's
my attorney. So Josh Allen is my daddy. LOL, sorry for the name. Hey, it's not one of the, I'm not going to comment on the name. It's not pay for it. Now, this is a double one I have for Adante to be my attorney. So, number one, how can anyone get a hold of you?
The food is on the court. It's on the pod. They always highbrow. You can get a hold of on Instagram. Lawyers like to, if given something from the charges, founding thing for the court, because now the court has to decide, okay, is this a mistrial?
So right at the top, how do you find the defendant? Not guilty or guilty? This is the question mark right now, because according to the juror note, some think guilty, some think not guilty. That's kind of the split that is happening right now. And this is to the predicate acts that Philip was just talking about there. If and only if you find the defendant guilty of count 1, which types of racketeering acts do you unanimously find were involved in the offense? So acts involving kidnapping, which of course would involve Capricorn Clark on the instance when the jury...
I mean, hypothetically, I guess they don't really have to check not proved or proved for each of the subcounts, but I don't know if they necessarily know that. Right? Yeah, maybe that's where they're hung up in terms of... That's an interesting way that this is written, right? Because it's like, what type of racketeerings do you find unanimously? And they don't necessarily need to find a unanimous opinion with respect to each of the subcounts or each of the eight predicates, right? For the purposes of the conviction, they just need to find unanimously as to any two of them. So it'd be interesting if they're hung because they believe that they can come to a unanimous opinion on some of them, but can't come to a unanimous opinion about all of them. It's like from the government's point of view, it's like we don't really care if you can't come to a unanimous opinion about all of them. As long as you can come to a unanimous opinion about two of them, we're happy. But they probably don't know that, and the form certainly doesn't allow for that or lend itself to that. So that's interesting.
Jewelry went missing, and she was allegedly taken to do that lie detector test. Or, for instance, when she says she was taken and kidnapped, involved in the Kid Cudi arson, the Porsche blowing up. Is this proven or not proven? Or rather, it reads not proved, proved. Acts involving arson. Of course, we're talking.
Right, because here they're not strictly speaking, they're not finding guilt on the sub elements or guilt on the predicates. They're finding that it's been proved, but they aren't finding guilt as to those things. Because that's a weird way of RICO, right? It's like you have to find the predicate, but they're not necessarily charged with the predicate. So yeah, like here, like proved beyond a reasonable doubt is actually different than guilty because of the nature of how RICO is charged, which is an odd duck, but that's the way it goes.
This Mia potentially, getting working and not getting paid overtime. But
what do the federal rules of criminal procedure say about partial verdicts?
Sex trafficking. Once again, going to Cassie and Jane. Was this not proved or proved? Acts involving transportation for purposes of prostitution. Not proved, proved. Acts involving drug distribution.
Let's see.
Only if you find the defendant guilty of count 1. Did the pattern of
trial
include sex trafficking of Cassandra Ventura? No or yes. This is the most important one at this time, everyone, because this is the one that the jury may be deadlocked on, cannot agree. After this, it reads, if and only if you find the defendant guilty of 1 count, did the pattern of racketeering activity include sex trafficking of Jane? No or yes. So, count 1 right there, heavy. There's a lot to break down, a lot
31B.
of crimes, and this is the question mark, everyone watching. This is the one where the jurors are seemingly deadlocked at this time. Now on to count 2.
All right, so it's Rule 31B. Very exciting for the jury verdict. Okay, let's look up what the rules are in federal court on partial verdicts because it'll be interesting. All right, so this is Federal Rule of Criminal Procedure 31. Very exciting. Of course, the jury must return its verdict to the judge in open court. The verdict must be unanimous. That much is true. All right, then we get the partial verdicts thing. All right, if there are multiple defendants, the jury may return a verdict at any time during its deliberations to any defendant about who it's agreed. Okay. Multiple counts. The jury cannot agree on all counts as to any defendant. The jury may return a verdict on those counts which is agreed. If the jury cannot agree on a verdict on 1 or more counts, the court may declare a mistrial on this count. The government may retry any defendant on a count which they haven't agreed. So, and then of course, jury polls. So the way that reads to me is that the judge can do 3 options here, right? So that's the way it reads to me. It's like the judge can either say, try harder, just keep trying. The judge can then presumably come back and be like, okay, give me your partial verdicts, enter the partial verdicts on the record, and then either declare a mistrial as to count 1 or have the jury go back as to count 1 and keep arguing about it. So they can accept the partial verdicts, enter them on the record, and have the jury go back and keep deliberating on count 1 for a while. So that's what I think the judge can do here. So we'll see which of those options the judge wants to go with. That's exciting.
About any one of those many different subparts. So it's not surprising. I think many of us saw that coming. Now, the other remaining charges, those are much more straightforward. And we saw that the jury, when they had questions, they sent those questions out about definitions and things. And the judge simply directed them back to those jury instructions. So I think that's why you're going to see that there was a unanimous verdict on those other charges, but they weren't able to agree with one on the RICO Act because there's...
I think if it were up to me as a judge, my inclination would be to accept the partial verdicts and order them to deliberate on the remaining verdicts. I think that's probably the way I would handle it. It's like, if you guys have a verdict as to some of the counts, I'll take it, enter them on the record, and order you to keep going about the rest. So, yeah.
a jury was even seated. And it's never really gotten easier, right? I mean, the more I talk about it, the more I personally understand it. But I also have a leg up on the jury, the fact that I can discuss it with my peers, and they've only had about 13 hours of deliberation, which, by the way, we have paused the verdict watch clock at 13 hours and 11 minutes because it seems overall we have overall we have a verdict.
Maybe.
On the first one, I'm going to go back to you, Philip.
Maybe we have a verdict.
Because you so astutely broke down all of those predicate
Will the court
crimes.
accept it?
What are your thoughts now that
Oh, you guys can't see this, sorry.
All of them. That seems to be the one that's tripping people up. So what do you think the judge is going to do?
Yeah, like, yeah, this is probably what's happening if I were a bet. You know what I'm betting is happening? I'm betting that they have not been able to reach a unanimous verdict as to proven or not proven with respect to all 8 subcharges. Now, from the government's point of view, again, the government doesn't care, right? As long as they have guilty as to any 2 of them, the government is happy. And so I don't know whether or not the judge can inquire or clarify relating to that. Because you can't really ask for partial verdicts within a count. So does that count as a partial verdict? I actually don't know technically. Because you're not finding guilt or not guilty, you're finding proven or not proven. So is that, I don't know how that works in terms of that. That's an interesting twist on the stupid.
Specific about the crime itself. So if that's the case and the jury is tripped up, good for Sean Diddy. Because it sounds like this jury will never, ever reach a unanimous verdict, at least as to 2 or more of the predicates.
Yeah, but if they're unanimous as to guilt as to any 2 predicates, the government would be happy.
Saying about all of that,
so that's how do you get that?
Deciding on the
because I'm willing to bet that they have guilt as to at least 2 of the predicates, which means that the conviction stands because they only need 2 of the predicates, but they don't know what to do about some of the predicates. So it's like, well, if I'm the government, how do I extract out of this jury the fact that they found unanimous as to proven as to 2 of the predicates? Because then I would be happy. Yeah.
Who are assisting on the case back in the office, be it on the defense side or the prosecution side. And I've been in that situation, and everybody can still get it.
Yeah, you need 2 of the predicates. That's right. But the form asks them as to each predicate. That's the thing, right? Ask them as to each of the 8 predicates, whether it's proven or not proven. So they would have to be unanimous with respect to all 8 predicates, either way. From the government's point of view, as long as they've proven 2 of the predicates, the government's happy. But what I'm betting is happening is that they have guilt, at least as to 2 predicates, probably, I would imagine. But some of the predicates they can't agree on either way. And so they don't know what to do. That's what I'm betting is happening. And like from the government's point of view, if I believe that, which I do, if I'm the government and I believe that, I'd want to figure out if there's a way I can get that information out of the jury without breaking the rules. Because as long as they tell me they have 2 predicates proven, I don't really give a shit about the other ones. I mean, I'm happy. So I'll take any 2. But how do I get that information out of the jury is a really interesting conundrum.
He's guilty. He'll still go to jail for those, right?
Yes, of course. They're certainly not going to release him.
It could hypothetically be not guilty as to those 4 counts. I mean, that's true too.
How much time he'll get.
But that seems unlikely.
So no,
it could be not guilty as to the other, counts 2, 3, 4, and 5. That's possible.
On count 1,
but that seems unlikely.
In fact, a mistrial is declared. The prosecution will likely retry him because, if I'm not mistaken, I think it carries life, and they definitely want to get him on that top count if they can get a life sentence.
A lot to think about here. I again want to remind anyone who has just tuned in that we have reached a verdict. The jury has reached a verdict.
Or have we? The jury has some thoughts they want to share, but we don't have a verdict, of course, until it's read and accepted in court. So
Where's Jesse? Where's Elizabeth?
We're
And let's answer
confused
those right now, because this is
we have a
really
we have a
interesting
we have a
time.
verdict in potentia.
House behind
That's what we have. We have a verdict in potentia.
So we can make sure to get the latest updates, be there to see how Diddy reacts to anything and everything like that. I promise you we'll have Elizabeth Milner on as soon as we can, but it's important for her to be in that courthouse.
I mean, they totally, absolutely could find guilty on the RICO without finding any of the predicates, or apologize, any of the individual charges. Because there was 2 counts of trafficking specifically, and 2 counts of, what was the other one? Distribution, wasn't it? Yeah. So there's 2 counts of trafficking and 2 counts of distribution. But they don't necessarily need those, because I don't know whether or not any other acts of distribution or any other acts of trafficking were shown or proven. But if there were other acts that they didn't charge individually, they could still find us to those on the RICO, because they don't have to necessarily find those specific trafficking or those specific distributions, right? They just have to find any distributions that occurred within the 10-year purpose period for the purpose of the RICO, which is incidentally why it says proven or not proven as opposed to guilty or not guilty, right? Because they're not being it's not a lesser included. It's not a lesser included of the RICO. It's a predicate for the RICO. It's a weird aspect of RICO. So you don't have to charge any of the underlying predicates. You could just have a RICO charge, right? And there are no lesser included of the RICO. And if you do charge particular predicates, it doesn't mean that they can't find proven as to other predicates that weren't charged. So the whole thing, RICO's a slightly weird beast because of the way it's written. It's a very weird. Well, it's I understand it, but it's kind of hard to explain it from first principles. It's a lot. Did they stop talking?
There,
okay,
breath,
apparently they stopped talking. So we're going to watch this for a while and see what exciting answer the judge comes up with. How does the judge want to resolve this problem? Does the judge want to say, please try harder? Does the judge want to say, return the verdicts you have and then declare a mistrial to count 1? Or does the judge want to say, return the verdicts you have and then order them to keep trying about count 1? So how does the judge want to resolve this problem? Yeah. Yeah, I don't know. And then like, is there a way to ask the jury is there a way to ask them if you're unanimous as to any of the particular predicates? Then tell me that. Is there a way to ask them that question? That's the one that's interesting. Like if you have unanimous as to any of the predicates, then check off those boxes and yeah. So yeah. Okay. Yeah. That's fun. What's count 1? The RICO. Yeah. Count 1 is RICO with the 8 predicates. Yeah. So that's what it is. It's RICO and then 2 counts of trafficking and 2 counts of distribution. And the predicates, and there are 8 predicates, which right away tells you, and incidentally, they're all distinct predicates. So only 2 of the predicates are charged individually because you need to prove any one crime, but you can't charge more than once within a predicate. So, distribution is only one predicate, no matter how many acts of distribution there are. You need to show 2 categories of predicate. So 1 is enough, and 2 doesn't do you any good or any more good. So only 2 of the 8 predicates are actually charged. And incidentally, as I said before, like they could not find those particular instances of the predicate. So they could hypothetically say not guilty as to those predicates, but also guilty as to the predicate in the RICO because there might be other offenses other than the 2 that were charged that they could find. So yeah, you're there. So yeah, this leads itself to all kinds of fun possibilities and combinations. If he's found guilty of the RICO, he's facing a potential life sentence. I don't think he'll actually get life, but I think that he will go to jail for a very long time, prison a very long time if he's found guilty of the RICO. Yeah. So, yeah. Will the other charges put him in prison? Sure. Yeah, I mean, they're all pretty serious under their own selves, so all the charges are serious. He's going to prison for some period of time for all the offenses. Yeah. Yeah. Do they need to ask versus instruct if you're unanimous as to any two of the predicates and also all the other amounts of crime you should find him guilty? Yeah, maybe they can do something like that. Yeah, then maybe there's a way to do that. Be like, just provide the instruction clearer. It's like if you find proven, to be more precise than guilty, but if you find proven as to any two predicates, you don't need to render an opinion as to any of the other predicates. So maybe there's some way to, do that makes sense. Well, did he have the right to appeal? Sure, you always have the right to appeal, but I wouldn't think there are any particular grounds to appeal, none that I'm aware of. So he can try to appeal, but there's no grounds to appeal that have come to my mind. Yeah. Yeah, Inner City Press says Diddy doesn't look happy. Yeah, because I think he thinks that the jury has found him guilty as to counts 2, 3, 4, and 5, which is also what I think. I think they found him guilty of counts 2, 3, and 4, and 5, which incidentally, by the way, would mean that they should find him guilty of the RICO. Because if they found two predicate acts, because they have distribution is one predicate act and trafficking is one predicate act. Now, they found 2 counts of trafficking and 2 counts of distribution, but it doesn't matter for RICO, right? Because you can only do one, right? So you need one, and more than one doesn't help you. So if they've proven counts 2, 3, 4, and 5, they've proven the predicate of distribution, and they've proven the predicate of trafficking, which means that if they find the other elements of RICO, which feels kind of like a given, then they should find him guilty of the RICO. So that's probably why he's not happy, because the jury probably should be finding him guilty of the RICO right now, but they just don't know what to do because the form doesn't really allow for that. Or maybe the instructions do, but yeah, I don't know what the instructions were that they were given. I don't know if the court ever entered them on the docket from yesterday. If the court entered the instructions on the docket, we can read it while we're waiting for the court to figure out how it wants to resolve this fun issue because of the complications. Yeah. How do you want to solve this problem, court? There are 8 predicates, right? He only needs 2 to be proven, correct? Yeah. Yeah. So there was arson. Yeah, arson was a predicate. I won't remember them all, but distribution was one. Kidnapping was one. So distribution, kidnapping, trafficking, arson. I think possibly transporting prostitutes is a separate predicate. And I forget what else, but yeah, there's intimidation of a witness, bribing a witness is one. And there's 2 other ones. But yeah, those are all predicates. I heard an Allen charge. Yeah, that's what the prosecution was floating. The prosecution was floating an Allen charge to solve this problem. But I don't think they've decided on anything yet. So if they find guilty on the lessers or the predicates, he's automatically guilty of the RICO? Pretty much, yes. Yeah, as long as you can prove the other elements of the RICO, but it feels like a given. You have to prove that there's an enterprise, which, there is, and that, the enterprise was used to facilitate it, which feels like a given for the other elements of RICO. So,
are the Mann Act violations, transportation to engage in prostitution, and those are the sex trafficking charges with respect to Cassie Ventura and Jane. However, they are unable to reach a verdict at this time with respect to count 1, the racketeering conspiracy charge, the top charge. Now, what just happened in court? Well, it becomes a question, what is the judge going to instruct the jury?
How are we
back and forth about
how are we solving this problem? That's how we want to know.
Charge. This is basically where the judge will tell the jury, keep on deliberating, keep moving forward, and then if they come to an impasse, if at some point they say, we just can keep to instruct the jury. Now, what just happened in court? Back and forth about whether they will provide a modified Allen charge. This is basically where the judge will tell the jury, keep on deliberating.
Yeah, so that's what they were arguing about.
And
but I don't know if the judge made a decision.
If at some point they say,
Dr. Barry's here, holla.
Decision, that's when we are dealing with a hung count as to respect to that count and possibly a partial verdict. In fact, prosecutor Maureen Comey says we are preparing a modified Allen charge. Sean Combs' defense counsel, Mark Agnifilo, says we propose you tell them to continue deliberating and that you not take the partial verdict. No modified Allen charge.
I'd take the partial verdict. I tell you what.
I'd
definitely take the partial verdict.
Agnifilo says yes. The judge says, okay, email your proposals, each side. I'll wait. I could give a modified Allen charge, or at some point, I could tell them that they could return a partial verdict.
I'd take it.
Email me. I'll wait.
I'd take that partial verdict. I'll tell you what, man. I'll do it.
And I will let you also know that at 4:54 p.m., Intercity Press indicated that in the well of the courtroom, everyone but Donaldson, Xavier Donaldson, one of Sean Combs' defense attorneys, is in their seat waiting. Sean Combs is leaning back. Because
remember in Bluford, right? The jury said, like, we have verdicts as to some of the counts, and the judge said, not good enough, keep trying. And then they didn't have verdicts as to any of the counts. Right. That was Bluford's Supreme Court case. And it was not guilty, I believe. Yeah. I think they said it explicitly, as memory serves. The jury's like, yeah, we are not guilty on count 1, which was like the murder count, but we can't decide as to like count 2. And the judge said, not good enough, try harder. And then the jury said, well, we don't have a verdict as to anything. And so no verdicts were entered, and that was ruled not to be double jeopardy. So again, I think I'd take the partial verdicts either way, just to make my life cleaner, but that's me.
Fine. I think they have found him not guilty with respect to sex trafficking of Jane, and here's why.
Maybe.
There is no way that you are going to have jurors who are potentially able to vote guilty of racketeering and would acquit him of everything else that he's facing. I don't see that working. I don't see that making sense.
They could.
Now, what happens?
It would make sense. It would be weird, but it could make sense.
Of testimony with respect to Cassie, whether it was the 2016 tape, whether it was Jane, whether it was the Cannes flight where Combs was allegedly showing her freak-off tapes. There was no and then there was also the part about Daniel Phillip potentially witnessing Sean Combs abusing her, this sex worker, this male performer. There was no request for a readback of Jane's testimony.
There's a copy of the jury.
I feel confident in this prediction.
All right, I'm skipping the audio for now because the court was kind enough to give the jury charge and put it on the docket. So thank you for doing that yesterday. So they did do it yesterday, put the jury charge. So we're going to see how the jury was charged. So we'll see what their instructions are relating to this and whether or not what that is. So yeah, if you want to modify those instructions, that gets tricky for a whole bunch of reasons. But let's take a look at what the jury was told to do and see if that helps clarify any of these things. All right, so how do I hold on. How do I make this bigger? Embiggen. How do I embiggen this? I forgot the embiggen button. Okay. There's got to be a way to do this. Oh, I know. Hold on. Hold on. Talk amongst yourselves. Let's try this again. Let's try it this way. Okay, I think if I do it this way. Aha, that works out a lot better. Excellent. All right. So this is the charge that was provided to the jury, which they have thoughtfully provided to me on the docket. And I will keep this over here, trying to watch what's going on in case there's any insight about what we're doing over here. All right. So let's see what it has to say on this issue. Let's see if there's. I'm going to skim to look for the part that I'm interested in. Burden of proof, reasonable doubt, blah, 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 direct circumstantial evidence, blah, blah, blah. Credibility of witnesses, blah, blah, blah. Yeah, Lord. Indictment, summarize the charges. Okay, indictment contains 5 charges. It summarizes what they are. Okay, that's great. Multiple counts. You must return a separate verdict, guilty or not guilty, for each count. Okay. Whether you find defendant or not guilty as to one offense should not affect your verdict as to any other. Fair. Okay, then they're going to define what attempt is legally, and aiding and abetting is legally. All right, so they define that for a while. Willfully causing the crime, they define what that is for a while. Okay, count 1 charges the defendant with a conspiracy to violate the Racketeer Influenced and Corrupt Organization Act, otherwise known as RICO. In order to prove the defendant conspired to violate RICO, the government must prove beyond a reasonable doubt each of the following offenses. So here's what you need to be able to prove to find RICO. First, that in or about 2004 through 2024, there is agreement among 2 or more persons to conduct or participate in affairs of an enterprise through a pattern of racketeering activity. So 2 or more people formed an organization for the purpose of the racketeering acts. Or if it not necessarily formed for that purpose, at some point it became that. So this could be, of course, a completely illegitimate organization like the mafia, but it could be a legitimate organization like a business that at some point decided to, among its lawful activities, also decided to do a little racketeering on the side. So, I mean, it could be either of those things. And it, of course, doesn't have to be necessarily formal. It can be a little informal as long as you have the group. So, okay, fair enough. That the racketeering enterprise or its activity would have affected or did affect interstate commerce. So that's your jurisdictional hook, of course. So it has to cross state lines. It has to cross state lines or affect interstate commerce. Okay. Third, defendant knowingly and willfully joined the agreement. So the defendant himself has to be part of the agreement. Okay. Point 4, the defendant knowingly and willingly agreed that he or another member of the conspiracy would commit 2 racketeering acts, as I define that for you. All right. So the first element the government must establish beyond a reasonable doubt is their conspiracy among 2 or more persons to conduct or participate in the affairs of an enterprise through a pattern of racketeering activity. A conspiracy is an agreement among 2 or more people to achieve an unlawful object. To show a conspiratorial agreement, the government must prove 2 or more persons explicitly or implicitly came to an understanding to achieve a specified unlawful object. Yeah, so there was an agreement to do an illegal thing. In order for the government to satisfy the element, you need not find the alleged members of the conspiracy met together and entered into any express or formal agreement. Similarly, you need not find the alleged conspirator stated in words or writing what the scheme was, its object or purpose, or every precise detail of the scheme, or the means by which it was going to be accomplished. So again, this can be done with a bit of a wink and a nod, right? It doesn't have to be like a formal board meeting, where there's like a resolution and people are like voting on stuff, right? It doesn't have to be, with minutes, taken down by a secretary and all right. Because the mafia probably doesn't have formal board meetings, or if they do, they don't call them that. And they definitely don't have someone keeping minutes. So it can be done a little bit more informally. That's fine. All right. What the government must prove is that there was a mutual understanding, either spoken or unspoken, between 2 or more people to cooperate with each other to accomplish the unlawful object. So as long as they agreed in some sense about, doing the illegal thing, you're kind of there. You may, of course, find the existence of the agreement to achieve the unlawful object has been established by direct proof. However, since the conspiracy is by its very nature characterized by secrecy, you can also infer it. So you don't necessarily need to find that you don't need to be able to establish to your own satisfaction that there was a meeting or any sort of other, like, you can infer it from the actions of the people that they were involved in a conspiracy. If they were all doing actions that furthered the same goal, you can infer the agreement to further the goal. So, I mean, fair enough, right? In the context of conspiracy, actions may speak louder than words. In this regard, you may, in determining whether an agreement existed, consider actions and statements of all those you find to be participants as proof of the common design on the part of the persons charged. So again, like, you don't need to confine yourself to the people charged, because there might only be one person charged, right? The conspiracy requires there to be more than one person, but you don't need to charge more than one person. So you can only charge one person if you want. So, and how many people are involved in the conspiracy is kind of up to you, as long as there's two. So you can consider any of their actions to speak to the design of the conspiracy. So, that's fine. In this case, the unlawful object would be to violate RICO. In other words, to conduct or participate in the affairs of an enterprise through a pattern of racketeering activity. An enterprise is a group of people or entities that have associated together for common purpose in engaging in course of conduct. It's an association. A conspiracy, almost by definition, is an enterprise, because a conspiracy is also a group of people that have associated together for the common purpose. So if you find a conspiracy, you kind of found the enterprise, because it's there, man. This group, in addition to having a common purpose, must be ongoing, either formal or informal, and structure. It must have a core personnel who function as a continuing unit. So that could be just the conspiracy, depending on the details, but it needs to have some persistence to it. So, fair enough. The group does not need to be a legally recognized organization, such as a partner or corporation. It can be, but of course, the mafia is not a legally recognized organization. So, yeah. The group may be organized for legitimate and lawful purposes, or may be organized completely for unlawful purposes. Yeah, like the mafia. Like, it can just be that we're here to commit crimes, or it could be a lawful business that decided to do a little racketeering along the way. So all that is exciting stuff. All right. The group must have a common purpose as a whole. Mere similarity of conduct, or the fact that individuals may have assembled together and discussed common aims and interests, does not necessarily establish proof of the existence of the enterprise, though you may consider it. There must be an overarching relationship among the enterprise members, and the enterprise must be formally or practically separate from the defendant himself. Yeah, we don't allow one-person enterprises or one-person conspiracies, at least in federal law. Georgia over here, with their state version of RICO, apparently is very happy for there to be one-person conspiracies and one-person enterprises, which doesn't really make sense. But Georgia, under its state law, is like, we're cool with that, which it doesn't really seem to work, but that's the way Georgia wants to fly. But in normal land, yeah, you need two people. Two people will be a minimum. An enterprise that includes individuals employed by the defendant can be distinct from the defendant himself, like a corporation, right? Because corporations have corporate personhood. So the defendant has to be part of the corporation, but it doesn't have to be the corporation, because that is mostly how that works. The government has charged the alleged enterprise in this case consisted of what's called the Combs enterprise, which includes Sean Combs, entities within Combs businesses, including but not limited to Bad Boy Entertainment, Combs Enterprises, and Combs Global, individuals employed by and associated with Combs business, and others known and unknown. So he used legitimate parts of his business towards an illegitimate end. So, okay. If you find the enterprise existed, you must also determine whether the enterprise continued in a substantially similar period from the period of the indictment. In this case, from 2004 to 2024. This doesn't mean everyone involved has to be the same, but the core of the enterprise has to be the same throughout, like a corporation. Like if you just treat it like a corporation, you will understand, right? So does the members of the corporation have to be the same? Like for the entire period? No, that's dumb, right? The core of the corporation has to remain, but significant changes in personnel does not mean the corporation no longer exists. You know? So a corporation might, for example, fire all of its C-suite. They could do that and then hire new people. So if they fire their entire C-suite and hire new people to be their C-suite, the core of the corporation would remain because the CEO is not the corporation or the CFO or the CTO or any of the Cs, right? So they're just people who serve the corporation. They're not the corporation. And the core of the corporation may persist yet, despite the firing of all of its upper leadership. So that's fine. So no problem there. The second element the government must prove beyond reasonable doubt is the criminal enterprise itself or the racketeering activities associated with it would have had some effect on interstate commerce. Yeah, that's just like, we can skip that, right? We can just skip interstate commerce. Yeah. And they just sort of, skip to the end of the page here by saying all narcotics activity, even purely local activity, has an effect on interstate commerce. You guys know this, right? Because you know this from Wickard v. Filburn. What is interstate commerce? Everything. What isn't interstate commerce is a better point, right? Yeah, asking what is interstate commerce is the wrong question. Asking what isn't interstate commerce is a much more insightful question. The reason is because what isn't is a much smaller list compared to what is. So just assume it's interstate commerce. And, the lawyers who want to play on the edges can deal with the really exciting niche exceptions, but just assume it is and call it a day. So we can skip element 2 because, of course, it's interstate commerce. Element 3, membership in the conspiracy. The third element the government must prove beyond a reasonable doubt is defendant knowingly and willfully became a member of the conspiracy, which, to be fair, is kind of like just true incidentally anyway. I mean, you have to willfully join a conspiracy. Right? And you have to be aware that it's illegal and pursuing illegal ends. So, for example, I can't speak to the finer points of motorcycle organizations like Hell's Angels. I don't know how Hell Angels operates, but I'm going to assume that they operate in such a way that some of their members are completely law-abiding. I don't know. I don't know how they operate, but I'm going to assume that some people who join Hell Angels are just motorcycle riders and don't do anything illegal and have no particular knowledge of any illegal activities. And so they aren't joining a conspiracy merely because some elements of Hell's Angels might from time to time engage in a little light illegal activity, right? You have to know and agree to participate in the illegal activity conspiracy. So you can associate. This is probably something you don't want to do because getting the jury to buy this is going to be a whole nother set of problems. Because you have to actually get the jury to believe this, which is a whole nother set of problems. But in principle, you can associate with every single person in a conspiracy. You can even know the conspiracy exists. Because mere knowledge of the conspiracy doesn't mean that you're joining the conspiracy. That's how this is how it gets, right? If you want to dance on the edge of what is legal, if you want to dance on the edge of what's legal, you can dance on the edge. So you can join a group of people to be involved in a criminal conspiracy. As long as you don't agree to participate in the conspiratorial acts, as long as you don't agree to participate in the illegal activity, you're golden. Again, probably don't want to do this because getting a jury to believe that's true is probably not going to end well for you. But from a strict legal posture, you can, right? Mere knowledge of illegal activity is not illegal. Mere association with people that you know to be involved in illegal activity is not illegal activity. Mere knowledge these people are engaged in illegal activity is not illegal activity. You have to do something to further you have to do something to join the conspiracy. You have to do something to express your willingness to be part of the conspiracy. So, yeah, I mean, that's true. You do have to show that he was, that he wanted, you have to show that he not only was aware that this was happening, but that he ratified it. So that's true. You think the jury went home for the day?
Through 5, they probably went through all of those, were able to agree a bit easier. And then to everything you just said, it's the racketeering conspiracy that is the most intense. It's the most confusing, especially when you bring in the predicate crimes, when we're talking about bribery.
Law and crime really needs to be able to get a clock that works. How does law and crime not have like clocks that work? That's what I want to know.
Because there are multiple different things to consider. So not only do they have to weigh the weeks upon weeks of
how hard is it?
Evidence and going through.
How hard is it for them to get a working clock?
Beyond a reasonable
How
doubt.
hard is it for them to get a programmer that can program a goddamn clock?
And exactly to what you were saying.
God damn it, law and crime.
By the way, that a lot of
there are not 69 seconds in a minute. Fuck you.
The fact that Diddy, Sean Combs is the defendant here, and there are no co-defendants. There are no alleged co-conspirators of this racketeering conspiracy, which generally has multiple co-conspirators. I mean, there may have been some, but they're not listed as co-defendants. So is that confusing for jurors? And perhaps maybe that's actually what it is.
They fixed it.
I agree with you.
Apparently they heard me, I guess. They heard me. They have realized that there are not 69 seconds in a minute. Could you just program a clock that works and you don't have to manually adjust it all the time? How fucking hard is this? How fucking hard is it to program a goddamn clock, law and crime? It's not that hard. I haven't written a piece of computer code in quite a long time. It has been a while since I've written a piece of computer code. I'm pretty sure that I could do it. Or, I could just find one that already works somewhere. You guys suck over there. Fix your shit, law and crime.
I'm not surprised that this is the one that everyone's really hung up on.
Yeah, and by the way, the jury has officially gone home for the night. So the judge says we've received a note that the jurors have concluded for today. We'll resume tomorrow. We'll bring them back out. Judge says all rise. Very briefly, thank you. Tomorrow, go directly into the jury room. Keep an open mind. Do not watch or read about this case. We'll see each other tomorrow. All rise. Judge asks the attorneys anything. No.
So are we not going to respond to the juror's note? At some point? Are we not responding to the juror's note? That's not really an option. You got to do something, man. What are we doing over here? I mean, I don't necessarily blame the judge for sending them home for the end of the day, but he's got to respond to this note, right? At least he has all day to think about it. But he's got to respond to this note first thing in the morning, right? How can he not? What the hell?
Not surprised by that. Sierra, stand by. Want to get a reaction to this from the rest of the panel. I'll go to you, Adante.
And, in the morning, they may not have the verdict they did now. Because, of course, there is no verdict, as we are all painfully aware, until it is read in open court. So they could come back in the morning and be like, yeah, we don't have verdicts anymore. So you let that opportunity slide by. God damn it. God damn it, fix your shit.
We have a super chat question that came in from M3 Voodoo. Love the show, Jesse.
The judge just told them to continue deliberating and follow their prior instructions. Is all he did, really? All the judge did was say, just follow my prior instructions. So just try harder. Okay, that's a valid option, but I was kind of expecting more, but okay. What is this, Inner City Press? All right. Let's see what they have to say about this. See if we can get some clarity on where we're sitting. Watch their thread from today. And let's see. Okay, so we did the note thing. Draws hands in his pocket. Sean comes sing by 8 lawyers are talking. Rubs his eyes, returns and hands a piece of paper, stares at it, looks down again with the note in his right hand. Okay. Okay, so then they discuss it. The United States attorney suggests an Allen charge. Defense suggests just try harder, no partial verdict. Would defense request I bring the jury out to say it? Yes. Okay, email me your proposal. I'll wait. Could get a modified Allen charge at some point. Tell me to return a partial verdict. There was a break. Let's see. All right. The judge says I received each side's proposal. For the defense, there's not much there. We're not remotely at the place where the jury needs to deliberate efficiently. They're remarkably efficient. They already have 4 verdicts, apparently. I wouldn't call the government's proposal an Allen charge. It reminds me of the jury instruction I previously gave on duty to deliberate. I could simply recite that from the jury charge. We're not at that point yet. I would say we wouldn't be at the point on Thursday. Let's wait and see. I'm putting stock that they've reached a verdict on 4 counts. Judge says, I'm going to go with that, but may give more later. I could tell them they could return on July 3rd. We could arrange that. What do parties think? We'd like to give the option to deliberate on the 3rd. So, yeah, so whether or not there's going to be deliberation on the 3rd, yeah, but the United States attorney would like there to be deliberation on the 3rd. Okay. Defense says our preference is you don't tell them now about Thursday. Downsized jurors might feel rushed to reach a verdict to avoid Thursday. Let them deliberate tomorrow. You can ask them at the end of tomorrow. So defense would no objection to deliberating on the 3rd. No objection if they want to. Okay, let's bring out the jury. So the judge says, welcome back. I received your note that you've reached a verdict on counts 2 through 5. I ask that you continue deliberating. Discuss and weigh your respective opinions dispassionately and follow my instructions. I ask that you return to jury room. If you decide you're done for the day, send me another note. I'll bring you at the end of the day. And then apparently they just send a note saying we're done for the day, which, fair enough. Like everyone wanted to go home. So that was it. And then, so the judge just said, we didn't give them the Allen charge. We gave them the light charge, right? We just gave them the please continue following my instructions. So the judge went for option 1. He did not accept partial verdicts at this time and just said, please try harder, softly. He didn't give the Allen charge yet because you can only kind of really do that once. So the Allen charge is the really, please try harder. So he gave him the light, please try harder, but not the please really, we really mean it, try harder charge. So yeah, exciting. What did the note say? The note said, we have a verdict as it counts 2, 3, 4, and 5, but can't resolve count 1. What do you want us to do? It was like the clearest note you could possibly want, right? No ifs, no hypotheticals. We have a verdict as it count 2, 3, 4, and 5. We can't decide what to do about count 1. What do you want us to do? And the judge said, please go back and try harder. Which, of course, the jury, of course, is free to reevaluate its verdicts at any time until they're accepted. So if one of them changes their mind for any reason, then we don't have a verdict as to counts 2, 3, and 4. There is no verdict until it's received in open court. So, yeah. They can change their mind overnight? Sure, of course they can, because the verdict is not read in open court. Yeah. There is no verdict until it's accepted. Yeah. And in Bluford, the jury said, they said we have a verdict I think they said we are not guilty as to count 1. The murder charge in Bluford. I think they said we're not guilty as to count 1, but undecided as to count 2. What do you want us to do? I think they actually said that. And the judge is like, please try harder. And then in Bluford, the jury at some point is like, okay, we still don't know what to do. And so they just declared a mistrial across the board. And the Supreme Court said that was fine. No double jeopardy issue. No double jeopardy issue because the court did not accept the not guilty verdict. So because the judge is not required to accept the partial verdict, right? The judge is not required to accept the partial verdict. And so it's like, please try harder. And so therefore there is no not guilty verdict. And therefore you could charge him again on the murder charge. That was the U.S. Supreme Court in Bluford. So it's like, yeah, this is one of the many reasons, incidentally, that like I continue to believe that, there was no verdict in a legal sense in the first Karen Reed trial for exactly this reason, right? The U.S. Supreme Court has no problem with this. So it's like, what do you want me to do? It's like, what do you want me to do, right? I mean, Massachusetts could, by its own state law, adopt a different position, but they didn't seem to be really interested in doing that. And the U.S. Supreme Court apparently has no interest in it. So it's like, well, what do you want me to do? It's like, it is what it is. I'm not here to tell you good answers. I'm here to try to educate you on the law. Law sometimes is a bitch. So, there's all that. What would be the benefit of not taking the partial verdict now? I don't know. Wouldn't it be to allow them to revisit one of the charges to help them come to compromise? Maybe. I don't know. I don't know what the judge is thinking in terms of accepting or not accepting the partial verdict, but he doesn't want to take it now. Maybe later, but not now. I look strung out. You think I look strung out? That's very rude. That's incredibly rude. Fuck you. Yeah. How long has the jury deliberated? Oh, not that long. 13 hours. Well, I guess it is relatively long. Well, not 20 hours, and it's a more complicated case because there's a lot of predicates, so it's more complicated. So 13 hours so far. Not that long. If this is deep state sanction operation goes to the Supreme Court on the case, it could do double jeopardy this thing. No, I just told you. The Supreme Court's already ruled on this issue in Bluford. So I already know what the Supreme Court's going to say because they already said it. And I don't think there's any particular reason they'd revise their opinion. So I don't think they'd change it. So the Supreme Court would not accept this case. And even if they did, I already know their answer because they told me the answer already in Bluford. So I'm like, okay, yeah, I know the answer. It's not ambiguous. This is not ambiguous. I know exactly what they would do because they already done it. So we're already there. You missed the hat. I don't wear the hat every single time. I probably should, but whatever. Yeah. So, that's sort of what we're sitting at. Anyways, let's continue on with reading the jury instructions so we can understand what the charge is, because RICO is confusing, and I can spend some time explaining what RICO is. This is confusing. Let's see. The weight loss is looking fabulous. Thank you. That's very kind of you. I appreciate it. Thank you. Yeah, I look strung out. I don't like that. It's like, I don't like it when people say I look strung out or they think I'm high or drunk or something. It's like, this is not fair. This is not nice. Is this what strung out looks like? Really? Seriously? This is what strung out looks like? I don't know, man. I don't think so. I don't think so, but okay. I'm not sure where you're getting any of this from. Did I get the watch? It is currently being held hostage by UPS at their distribution center. The company sent the information that UPS wanted, and they released the watch from impound or from customs. And the watch is still like not moving though. And there are no updates right now about the watch. The watch is now just like sitting in their warehouse somewhere. I'm concerned they may have lost it in their warehouse. Because it's like there are no updates relating to this thing. It's like this should have been on a truck by now, and it's not. Yeah, the last activity was, well, let's see, the 30th, it'll 1031 import scan. That doesn't make sense. So on the 27th, there was an import scan in Louisville. And then yesterday at 10:30 p.m., there's also an import scan. Maybe that's a good sign. So at least, I mean, they scanned it, right? At 6, they scanned it last night at 10:30 p.m. So maybe they haven't lost it. In any event, I haven't gotten it yet. So anytime they want to deliver it to me would be fine. Yeah. The QR code is covering the tiger. That's a fair point. It is covering the tiger a little bit, but I'll figure that out later. Who's in the pic next to the Clemson sign? That's Norman Rockwell. That's Norman Rockwell's freedom of speech. Yeah, that's Norman Rockwell. This is also Norman Rockwell. You guys don't have art. You guys don't know your art, I guess. That's all right. The second import scan is when customs released it from impound. Okay. Well, maybe that's a good sign. Maybe it will come tomorrow. Maybe it'll come tomorrow. Maybe they'll put it on a plane overnight or something. And one can hope. We'll see. All right. Anyways. And then we can decide whether or not it was a good purchase or not. Which should be an interesting discussion for everybody, I assume. It's like, okay, I have two watches that look exactly the same, pretty much. They look exactly the same. I mean, the hands are the same. The markings on the bezel they look the same. All right, one of them, the one I'm wearing now, is $120. The one I just bought, which looks exactly the same, is $1,500. So like, okay, is it good that I spent, what is that? 13 times what this watch cost to get one that looks exactly the same? I mean, we'll figure it out. We'll get back to you on that. On the plus side, as I've stated before, the amount I paid was actually a pretty good deal for the watch, based on trending prices. So I got a pretty reasonable deal out of this. So if I change my mind, I should be able to flip it and get all my money back. So, if not actually a slight profit. So I got that going for me. So we'll see how it goes. From Amazon? No, the first watch is from AliExpress, from a Chinese watch company. Yeah, not from Amazon. So it's Chinese watch. And the second one is a German watch with a Swiss movement. It's made of German submarine steel. That's pretty cool. What kind of watch? Well, the watch is the Zinn U1. S-I-N-N. It's pronounced Zinn. The Zinn U1 is the watch that I bought. The watch I have now was made by Steel Flyer, and I think is the SF782, I think, if memory serves correctly. But that model number may not be exactly right. Yeah. So, yeah. It's an automatic. They're both automatics. So the watch I have now has the NH35 movement. The watch I bought has the Sellita 200 movement. So, I mean, there's not. And the watch I have now the watch I have now says it's rated for 200 meters. I'm not sure if I believe it. The watch I'm buying says it's rated for 1,000 meters, and I believe it because it's actually tested by like a real company and stuff, you know, and all that. Yeah. So I believe it. So it's like, yeah. Yeah. So we'll see that. Anyway, any event. In deciding whether the defendant was a member of the conspiracy, you should consider whether the defendant knowingly and willfully joined the conspiracy. Defendant must participate in the conspiracy with knowledge of its unlawful purpose and with specific intention of furthering the unlawful objective. Defendant must be connected to the enterprise in some meaningful way, and defendant must know the existence of the enterprise and general nature of the activities. An act is done knowingly when it's done purposefully and intentionally as opposed to mistakenly or inadvertently. A person acts intentionally when he acts deliberately and purposefully. That is, the act must have been the product of consciousness, objective decision, rather than the product of mistake. To act willfully means to act voluntarily with intent to do something the law forbids. That is to say, with bad purpose, either disobey or disregard the law, although the defendant need not know the specific law that they're violating, but they have to know that they're doing a bad. They have to know they're doing a bad. They don't have to know the specific bad, but they have to know they're doing a bad. So yeah, they have to have moral guilt, I suppose, in some sense. All right. The defendant's mere presence at the scene is not in and of itself make him a member of the conspiracy. Yeah, you can hang out at crime scenes with members of the conspiracy, and it doesn't mean that you're part of the conspiracy. You know, it obviously doesn't mean that. See, because that doesn't make any sense. A person may know or be friendly with a criminal without being a criminal himself. That's right. You're allowed to associate with criminals unless you're on probation. Lol. You're allowed to associate with criminals, and it doesn't make you a criminal. Mere similarity of conduct or the fact they may have assembled together and discussed common aims and interests does not necessarily establish the conspiracy. What is necessary, the defendant must participate with knowledge of the objective of the conspiracy and with intention of aiding and abetting it. So even if they had discussions about the conspiracy, it still doesn't implicate you. Again, please try to avoid doing this. The lawyer in me would very much appreciate that you not try to ride the line. Okay? Because the closer you fly to the sun on this, the more problems your future defense lawyer is going to have. Okay? So we strongly encourage you to please not ride the line because it's very easy to fall off the edge of the cliff. But yes, technically, you can know about the conspiracy. You can know everything about the conspiracy. You can have discussions with the conspirators about the conspiracy, as long as you don't intend to join the conspiracy or try to further their aims. So, you know, you could, I'm not sure what you're doing here, but you could hypothetically just be friends with the mafia. I don't know why they're doing this because it sounds like a bad plan. But you could just be friends with the mafia and you just like to hang out at the mafia meetings as they're discussing their business. And Tony Soprano's over here telling you about their, you know, plan to do whatever it is they're doing. And all the other members of the group are telling you about all the fun crimes they've committed and will commit in the future and their plans to like bribe some politicians or whatever. And you can sit there with that, sit there and be like, okay, that's cool. Interesting. All right, cool. All right. Nice to know. I'm going to go play some pool now. All right, thanks. Thanks for coming to the meeting. Yeah, I mean, probably not a good idea to try this plan, but it would be technically legal. So, you know, okay. The fourth element the government must prove beyond a reasonable doubt is the defendant knowingly and willfully agreed to participate in the conduct of affairs of the enterprise through the pattern of racketeering activity. The focus of the element, I mean, you could be a lawyer. You could be actually just a legitimate lawyer for the conspiracy, for the members of the conspiracy. So that would be, I guess you're just their lawyer. And so you're their lawyer and you're going to the meetings wherein they will tell you about the things they're doing. Now, I should point out though, as your lawyer, you need to tell them that them telling you about future crimes is not them telling you about future crimes is not privileged. So past crimes, privileged. Future crimes, not so much. So you as their lawyer probably shouldn't be there for these discussions because you'd actually be required to testify about it. And it seems like a bad plan. But it would be legal, if not perhaps advisable. The focus of the element is on defendant's agreement to participate in the unlawful objective of the enterprise to engage in pattern of racketeering activity. The government must prove defendant agreed to participate in the enterprise with intent that he or another member of the conspiracy would commit 2 or more racketeering acts, which I'll describe. The government is not required to prove either the defendant himself agreed to commit the racketeering acts or he himself committed to 2 acts, right? So he doesn't need to agree to commit the acts themselves. He has to agree that the acts being committed would be good and he would like them to occur. But you don't need to prove that he actually pulled the trigger, as it were. A pattern of racketeering activity requires at least 2 acts of racketeering that occurred within 10 years. To establish the agreement the enterprise would engage in a pattern activity, the government must prove 3 things beyond a reasonable doubt. First, the government must prove defendant agreed that the defendant or a co-conspirator would commit 2 or more of the acts I described. 2 separate acts of the same type are sufficient to satisfy the requirement. You must be unanimous as to which particular racketeering acts, if any, the defendant would agree to commit. But they weren't asked about. So the instructions say it's okay to find 2 acts of the same type, but they weren't asked about that on their verdict form. They were only asked, do you find about the type? So they can't actually find 2 of the same type because they weren't asked about it on the verdict form. Okay. Second, the government must prove racketeering access has a nexus to the enterprise and racketeering activities are related to one another. For a racketeering act to have a nexus to the enterprise, it must have some meaningful connection to the enterprise. To satisfy this element, the government must establish the defendant was enabled to commit the offense solely because of position in the enterprise or involvement in or control of the enterprise or because the offense related to the enterprise. So one of the ways you can prove that it's connected to the enterprise is that the offense would not or could not have occurred but for the enterprise. The enterprise enables it to exist, or it helps to further the objectives of the enterprise. It furthers their purpose. So exciting. Is there a solo cup tumbler? No, but we should probably have one. That'd be awesome. Why don't we have a solo cup tumbler? That's actually a good point. Someone tell Jinx to please create a solo cup tumbler. We should have one for sure. All right, to be related, the racketeering acts must have same or similar purpose, results, participants, victims, or methods of communication, or otherwise be interrelated and not isolated. So they have to kind of relate to each other in some way. They have to be for the common goal. Third, the government must prove the racketeering. Yeah, so you can't just have like 2 acts that are predicate acts but they're isolated and not related to the conspiracy. So, I mean, the acts themselves are still illegal, but if the acts hypothetically exist outside the conspiracy or otherwise isolated, then it doesn't count. So if you're a mafia member and are on your own without any particular knowledge of anyone else performing actions that are illegal, they may not necessarily tie to the conspiracy depending on a whole lot of details. It's possible in principle, especially if they don't relate to the purpose of the conspiracy. Because you can only stretch this out so far. So if you have acts that are unrelated to the conspiracy, then you're not liable for that because you're only liable for acts that further the conspiracy. Conspiracy law is fun. When we go dance on the edge of the page. Again, it would just be a lot easier to not join criminal organizations, really. That's just the easiest way for you to solve this problem. Again, you can, join the conspiracy criminal organization without you yourself being a criminal. But if you just don't join the criminal enterprise or the criminal organization, if you just don't join them, you will save yourself potentially a lot of headache. You know, so I'm just saying, you know, it probably just best to stay away completely for many reasons. Nate the lawyer's here. How are you doing, Nate the lawyer? It's good to see you, sir. How are you doing today? We love you, Nate. You know that. I was just explaining to them RICO. As I was going through the charge of RICO. Would you like to join the stream for a while? I could try to set up a link if you're like. Let me go ahead and do that on the premise that Nate will say yes because he likes me. That's what I'm going with. One moment, please. Definition join, yeah. It's fun. Yeah, please try not to dance on the edge of what is legal. Probably not good for many reasons. Happy Canada Day. It is Canada Day to our Canadian neighbors. That's true. In honor of our Canadian neighbors, I will sing the Canadian national anthem because we love you, Canada, despite recent troubles. All right. Oh, Canada, our home and native land, true patriot blood in all thy sons command. With glowing hearts we see thee rise, the true north strong and free. From far and wide, O Canada, we stand on God for thee. God keep our land glorious and free. O Canada, we stand on God for thee. O Canada, we stand on God for thee. Happy Canada Day, Canadians. Sorry for butchering your national anthem, but it was done with love. So hopefully you'll forgive me. What is Canada Day? Canadian Independence Day. It's Canadian Independence Day. It's Canada Day. It's Independence Day in Canada. All right. Oh, there's a new version of the anthem? I didn't know. They changed the lyrics. See, I learned the lyrics of the Canadian national anthem like when I was like 15. Did they change the lyrics of the anthem in the last 30 years? Have I disrespected Canada? I apologize, Canada. I've disrespected your country by not apparently singing the updated version. I didn't know there was an updated version. I tried so hard and I insulted your country. I am sorry. I was just trying to show love. They still share a sovereign with the UK? Yeah, they do. Well, be that as it may. Yes, they're one of the Commonwealth countries. So yes, they share a head of state with the other Commonwealth countries because that's the way they like to roll. Which, you know, what do you want from me? It is what it is. I don't make this stuff up. I'm not responsible for any of this. All right, I don't know if you're still here, Nate, but I'm gonna send you a message with this link. So if you want to join. All right. How could I possibly remember that? I don't know. From 30 years ago? I don't know. I do, though. So I don't know what to tell you. Mm. Did they change the lyrics of Canada Day on me? What? Hold on. Okay. All right. Yeah, let's see. Okay, so this is from Canada.ca. So I'm going to go with this is pretty official. This is apparently from them. All right. O Canada, our home and native land, true patriots love, and all thy sons commit, and all of us. Instead of all thy sons, it's now all of us. Instead of all thy sons, now it's all of us. Lame. With glowing hearts, we see thee rise, the true north, strong and free, from far and wide, O Canada, stand on guard for thee. God keep our land glorious and free, O Canada, stand on guard for thee. We stand on guard for thee. So they changed sons to all of us. Lame. Lame. And it's guard, not God. So, yeah. Okay. Well, I got close. Lame. Lame. I tried. I tried. I did my best. Third, the government must prove the racketeering acts pose a threat of continued racketeering activity. To satisfy the requirement, the government must prove beyond a reasonable doubt the acts are part of a long-term association that exists for criminal purposes, or the acts are a regular way of conducting the affairs of the enterprise. I'm going to now explain the specific racketeering acts that are alleged in the indictment. There are 8 of them. I'm going to go through them one at one. The indictment alleges the following racketeering acts were or intended to be part of the conspiracy: acts involving kidnapping, acts involving arson, acts involving bribery, acts involving tampering with witnesses, acts with the forced labor, otherwise known as slavery. We don't really like the slavery. Acts involving sex trafficking, acts involving transportation of people for the purpose of prostitution, and acts involving the narcotics. In the moment, I'll instruct you in the substantive law of each of these offenses. Please don't. Before I do, let me remind you the government must prove beyond a reasonable doubt the defendant agreed that either he or a co-conspirator would commit 2 of the offenses within 10 years as part of, they must prove that the defendant agreed they commit 2 of these offenses within 10 years of each other as part of the activity. As I've said, the government need not prove the government himself committed or agreed to personally commit these offenses, nor is the government required to prove any of the acts actually occurred, right? Because it's a conspiracy to perform the acts. They don't necessarily need to actually do it. They need to agree that they'll do it, but they don't actually need to do it. So you also note that for some of the charged offenses, the government alleges a violation of more than one statute. You need not find the object of the conspiracy involved violations of all statutes pertaining to the offense. Rather, you need only involve at least one of the statutes. However, you must be unanimous as to which one. Okay, that's exciting. Why is my face so incredibly red right now on the screen? What's that all about? My face is just unbelievably red. Or purpley. Am I purple? I'm kind of purpley. What the hell, man? What's all that about? I don't like the way I look on camera. I don't like this at all. I don't like the way I look. Maybe if I shift the color palette on my camera to like take more of the red out. Because I shifted it back to neutral. Maybe I need to shift it back to like a green bias. So maybe let me shift it back to green bias because this is pissing me off. All right. All right. Okay, that's better actually. Yeah, 2 steps. 2 steps will do it. Okay, that is a lot better. See, that is a lot better. So yeah, just shift the color scheme 2 steps towards green. That is a shit ton better. I don't hate myself as much right now. Excellent. Yeah, we'll just shift the color scheme to green. Biased. Excellent. Fixed in the camera. Very good. You think it's too green? I mean, I could go 1 step less, but I don't know that I agree. You think it's too green? I don't know, man. I don't think I agree. Yeah, I don't think so. All right, let's do this. I'll now explain the law governing the 8 types of racketeering acts. We are not going through those all. We are not going through the acts individually. You know what the drill is. You know what the offenses are. It's fine. It's too green. It's fine. Not too green. Some people think too green. Some people think not too green. So, all right, I'll tell you what. We'll try one step less and see what we think about that. I'm not promising to stay there, but we'll try one step less and see what this is. All right, that's one step less. Even one step less is better. So, but I still think I look too red, to be honest. I think I still look too red. Yeah, in the camera I do. Yeah, I still look too red. Yeah, no, I don't like it. I don't like it. I don't like it. I'm going back to 2 steps. There we go. I'm going back to 2 steps. Fuck it. Okay, I'm going back to 2 steps. I like it better. That is my decision. Get off my lawn. All right, so we're going to discuss the things, and it's all good. Yeah, the jury's gone home for the day. Yeah, the jury's gone home. So now they're going to define all the crimes. We know what we know what it is. Like, I don't need to tell you what the crimes are. You know the drill. So we can skip all that. That's why people on camera wear makeup. Fair. Yeah, I mean, I could put on makeup, but I'd have to do it every time. So I usually don't do it anymore because it's a little tedious. But maybe for long streaming, I really should. Maybe I should put on makeup when I stream long periods. I don't know. But I have some like basic, me powder that's tinted. So yeah. Is the verdict length the usual? Yeah, so far. I mean, there's nothing weird about it. Think how hard it is to be a woman? Okay. Do I use a ring light? No, I have a light box. Okay, then there's the statute of limitations, so all that, special sentencing factors. Now they're going to explain count 2. Colored lighting. I could change the color. I could change the lighting color to be a little green. I've tried that before with changing the color to be slightly green. I could try that. Unanimity. Okay, yeah. So, yeah, basically that's what they need to prove. They need to prove those things. So we'll see how that goes. Cool. Yeah. Haven't conservatives tried to make men wearing makeup in public illegal? No. I know of no conservative proposal in recent memory to make men wearing makeup illegal. No, not so much. So that's kind of the end of that charge. We'll see what they do tomorrow. We'll see if they have any thoughts tomorrow. The background is green? Not really. You can do the trick a lot of women do, which is just white out your face with a super bright light. No, it's okay. Look up Florida's drag bills. You're trying to tell me that Florida is trying to make the mere wearing of makeup by men in public illegal? I bet you it doesn't say that. What do I get if it doesn't say that? What do I get if I look up the Florida drag statutes and it doesn't say that the mere wearing of makeup by men in public is illegal? What do I get? Before I waste my time. I'm pretty sure it doesn't say that. Yeah, guarantee it does not say that. Yeah, there's no way it says that. Yeah, there's no way it says that. Yeah. Yeah. Yeah, silly. It's silly. Yeah, there's no way it says it. It's like I don't need to look it up. I know it doesn't say that. There's no way it says that. It's dumb. It's dumb. Yeah. So they can't be unanimous on the count one. What happens? I don't know. Depends what the judge wants to do at some point. So I don't know. Yeah, I don't know. At some point, the judge might allow partial verdicts and then give it charges to count two specifically or something or whatever. Yeah. Such as SB 1438, which focuses on restricting venues from admitting minors to adult live performances. Yeah. So it's not merely men wearing makeup in public now, is it? It sounds suspiciously like you just added other things to it. Yeah. It sounds like you added other things. They're trying to prevent cross dressing, though. Again, I'm pretty sure there is no Florida law that's been proposed, that's even been proposed, let alone adopted, that says mere cross dressing is illegal. I'm pretty sure that proposal does not exist. Because that sounds like that doesn't make any sense. There's no way that merely cross-dressing is illegal or has even been proposed to be illegal. Will there be any verdicts read tonight? No verdicts tonight. No verdicts tonight. Jury's home. No verdicts. So our wait continues unabated. While the bills don't mention makeup specifically, they use vague language like lewd conduct and adult live performances. The opponents could be argued to use to target drag shows. Well, even if they're trying to ban drag shows, even if they were trying to ban drag shows, that would still not be merely men wearing makeup in public. So, yeah. There's more things. It's more things. Adult live performances, means any show, exhibition, or other presentation for a large audience, which in whole or part depicts or simulates. Yeah. Okay. So that's not merely wearing makeup now, is it? Yeah, that doesn't make sense. You've reduced it to the point of unhelpfulness. Yeah. And they're not even trying to ban drag shows. At that, they're trying to ban drag shows in which minors are present. So not only are they not trying to ban makeup, they're not even trying to ban drag shows. They may be trying to ban drag shows in which minors are present, but that's a little bit more specific now, isn't it? So, like, yeah. This is why it's helpful to be precise in our thinking. Yeah. Exposing children to adult live performances. Right. So, again, they're not even trying to ban the adult performances. Are they? They're not trying to ban the adult performances. They're trying to ban exposing children to the adult performances, which may include drag shows. Like, okay, maybe, but like that wasn't the original statement. So, like, yeah, okay, so they might be trying to, okay, the Florida legislature might be trying to ban at least some drag shows, potentially not all, but they might be trying to ban some drag shows for which minors are present. Okay, I'll concede to that. I'll concede that the Florida legislature is trying to ban children from being present at least some drag shows. Okay, I'll concede that point. Okay, great. So what do you want to say now? What do you want to say about that? Yeah. It was passed in 2023. Okay. Then the Florida legislature, well, has potentially banned. The Florida legislation has potentially banned at least some drag shows in which children are present, as opposed to trying to. They have banned some drag shows in which children are present. Okay. Noted. All right, great. I concede the point. What are we talking? What's the next thing in this discussion? Now that I've conceded that Florida has in fact banned some drag shows in which children are present, what's the next part of this discussion? Yeah. 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 What's the next part of this discussion? There probably are some drag shows which are too lewd for children. I mean, if you don't think it's possible for a drag show to be too lewd for a child to attend, I don't know what to tell you. If now maybe Florida went too far in its definition and we could have that debate, but but if you want to say, okay, Florida drew the line in the wrong place, they're banning too much conduct, I suppose we could have that discussion. But if your premise is that it's not possible for there to be a drag show which is too lewd for children to be present, I don't know. I don't know how we can have that discussion. I don't know how we can talk. I don't know we can have that discussion. It's like if you can't agree that there are at least some drag shows that are too lewd for children, I don't know what we're talking about. Maybe Florida drew the line in the wrong place, but the idea at least is like sound in principle, right? So maybe they drew the line in the wrong place, and we could have a discussion about that. But if your premise is all the drag shows must be okay for kids, I'm like, no, that's a dumb thing to think. That's a dumb thing to think. Well, sexual is what makes drag. Well, not strictly speaking. No, drag is just dressing up as a woman, potentially fairly convincingly. So drag doesn't necessarily need to be sexual. Drag could just be trying to dress up and pass as a woman. not necessarily for sexual purposes. Perhaps for artistic purposes, but not necessarily. It doesn't necessarily have to be sexual for it to be drag. So that, yeah. Yeah. I thought it's cross-dressing. Well, at least to me, I would use cross-dressing and drag synonymously. I would use the term synonymously. So for me, there's no difference between cross-dressing and drag. I mean, we could look at see what the dictionary says and see if the dictionary agrees with me. But I just think that drag, I always conceived of drag and cross-dressing as just being the same thing. But what does OED have to say about it? When in doubt, let's go to OED and see what it has to say about what drag is. By definition. Hey, Nate the lawyer's here finally. Hey, Nate the lawyer, how are you doing? You finally showed up.
I just saw the thing that you said, so I was like, okay, let me click onto it. What's going on, man?
Not much, man. We were just having a discussion over Florida, and we were going to look up what the definition of drag was.
That's what you got to do.
I have posited that drag and cross-dressing are synonymous. I've posited that they're the same thing. So we were going to look it up and see whether or not the dictionary agreed with me.
That's like Urban Dictionary stuff, though. Let me see.
We were gonna look it up in OED because OED knows everything. But how are you doing lately?
I'm doing all right. I just went over that whole Diddy verdict. Well, so or Diddy verdict versus non-verdict.
Yeah.
So, but it's interesting because people are all upset. They're like, "Oh my God, there was no verdict." I'm like, there is a verdict. There literally is a verdict. It's just they're not telling us what it is as of yet. But there's a verdict, all right. So, what do you think?
As we're all painfully aware, there is no verdict until it is announced in open court. And hypothetically, the jury could change its mind about there being a verdict, and it's happened before. So,
say it one more time.
The jury could change its mind about there being a verdict because it hasn't been received by the court yet. So, if the jury is like, "Well, we changed our mind," they can change their mind.
Oh, because they haven't entered it yet?
Yeah.
Is it possible? No, because as soon as they tell the judge, all right, so they tell us we've reached verdicts on count, blah, 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 and he goes back and says, okay, those are in. Now you only consider. Well,
yeah, but once they're read by the court and entered into the record, right? But if that doesn't happen, then the jury can change its mind.
I don't know. That's an interesting quirk. I don't know, because I've seen cases. Well, because I know I was telling somebody else, I was involved in a case where it was this type of thing where it was like multiple counts, but the jury was like, all right, on these counts we found guilty and these was not guilty. But these couple we can't figure out as of yet. So they read those verdicts. The Daniel Penny case. They did the same thing with that case. Remember? They were like, we can't reach verdicts on these, and then the judge was like, all right, we'll just remove those and go back to that one. Go to the manslaughter. And then they came back not guilty. Remember, they were split on the murder, and then they removed the murder and they say, just give us manslaughter. And then they said, well, we can't do he's not guilty on the manslaughter.
Yeah. Well, I can actually help you out on the legal point because the Supreme Court actually has decided this issue already.
Okay.
So we're going to pull up Bluford real fast, if I can find where I put it. Okay. So, yeah, there's the U.S. Supreme Court from 2012. The double jeopardy clause protects against being tried twice for the same offense. The clause, however, does not bar a second trial if the first ended in mistrial. Mm-hmm. Okay, critically in this case, before the jury concluded deliberations in the case of Bluford, it reported that it was unanimously against guilt of charges on capital murder and first-degree murder, was deadlocked on manslaughter, and had not voted a negligent handslide. So they say, we are not guilty as to count one. Mm-hmm. We don't have an opinion on count two, and we haven't gone to count three. The court said, I'm not accepting any of that. Go back, try harder. The jury did so, but then reported it couldn't reach a verdict at all, and the court just declared a universal mistrial. All agree that the defendant may be retried on charges of manslaughter and negligent homicide. The question is whether they may be retried on capital and first-degree murder, and the answer was yes. So even though the jury said we're not guilty as to count one, because the court didn't accept it and told them please try harder, then it was not double jeopardy, and
so it didn't trigger.
There was no verdict. Yeah.
All right. No. So I understand. So in other words, you're saying this didn't trigger double jeopardy because it wasn't announced. But this is so I think this still leaves open the procedural question, because in certain state courts you could have that where they enter those other charges. All right. In other words, you fill out the form, those verdicts are entered now. Just go back and consider this other one.
I'm not disagreeing with you.
Yeah. So now I'm saying the jury now. I'm not sure if the jury can even go back and reconsider those first.
No, not once they're entered. Not once they're entered by the court. I agree with you.
That's what I'm saying. So now,
if the court received the partial verdict and entered them and put them on the record, then those counts would be dead. That's true.
Now, see that that's what I'm saying. I'm not sure, because we're not talking about the Constitution. Well, I'm not talking about the Constitution. I'm talking about the process in which this thing happened. Because in each jurisdiction, there's different processes, and the process I'm talking about is. That's the process in federal court, I'm assuming. You got to do them all at the same time.
Sure.
But I'm saying, but in every state, they have different processes. So I'm saying in certain states, I'm not sure if New York is one of them, where once the jury's entered the verdict onto the sheet, they can't consider that anymore. And the situation you're talking about is the jury can go back and reconsider everything. But that's not what's going on here. The jury just said, the judges sent them, well, look, I'm accepting the first four, but just go back and consider one again. So
no, I don't think the judge said that. I don't think the judge said that he accepted the four. I don't think if he accepted them, they would have been read into the record. They would have been
read. Okay.
Yeah, if he accepted them, he would have been like, okay, what's your verdicts? And he would have read them into the record and entered them. That didn't happen.
Yeah, see, I don't know, because I'm assuming. I think you have to definitely put them on the record on open court, but I'm not sure procedurally. Well, no, but this is federal court too, anyway. So I think you're right. Yeah. So this is federal court. So I'm thinking state court, but you're right. This is federal court. So if that's the rule, that's the rule in federal court. Yeah. So they can go back and reconsider everything in federal court. Because I know in certain jurisdictions, I'm more than positive they can't just like when you reach the verdict on something you've told the court, you can only then go back on what you haven't. You can't go reconsider the other ones. But they may. But I mean.
Well, what you're basically telling me is that there's some state in which the court is required to accept a partial verdict. And that might be true. There might be a state in which they're required to accept a partial verdict. So if the jury said, we have a verdict as to some count, the court is required to receive it and enter it. So that might be true in some state, maybe. Yeah. It's not true federally. I know that for sure.
Yeah, for federally, I'm assuming that, because I've seen partial verdicts be read where like again, where they've read out the partial verdict and then say go back and just do this one. And,
and the federal rules allow for that too. The court can receive a partial verdict. It was true in Massachusetts as well under their state rules. The court can receive a partial verdict. It's something they can do, and they can order the jury to keep deliberating on the remaining counts if they want. They can do that.
Yeah.
So that's fine, but they don't. I don't know if any state that requires it, but there might be some state that requires it.
I have to look it up. So what I will ask you though is that, all right, so what do you think the outcome of this one is? Because there are 5 counts. The two, I think, well, right now, again, this is my reading of the tea leaves. It could be totally wrong, totally wrong. But my reading of the tea leaves. Usually, fast verdicts mean guilt. Right, fast verdicts generally mean guilt, unless you're OJ. And OJ is one of the few cases where fast verdict meant innocent. But generally, R. Kelly was 2 days. Nexium was like 5 hours. Weinstein was like 4 hours. So generally, this was a day. So with that, the transportation for prostitution, I think they got them still dead to rights. You got the prostitutes they asked for earlier in the day. They asked to read back the testimony from the escort that said he was flown out. So I think those 2 counts, they got him dead to rights. And I think the jury's probably found him guilty of those. But those aren't really serious counts. You can get up to 10 years in prison. So what I mean by up to 10 years is it's a minimum of essentially 1 for the felony and up to 10 years. And he's a first-time offender, so he's not looking at 10 years. He's probably going to, if that's the only thing they caught him on, he's probably looking at a walk with some probation, right?
Maybe.
That's essentially what that is. It's essentially a Mann Act violation. Okay, so those 2 I think he's guilty on. Sex trafficking, there are 2 counts of that. Now, everybody's talking RICO, but I think people fail to realize the sex trafficking charges are actually the more dangerous ones because they have minimum sentences of 15 years, where RICO doesn't have a minimum sentence. RICO is 1 year to life, because it really depends on the predicates that you have. Let's say, for instance, in RICO, if one of the predicate felonies is murder, and it's a life sentence, then the RICO automatically turns to a life sentence. But if if the predicates are prostitution, for instance, and they're 10-year, they're 1-year minimums, then the judge has the flexibility. I'll give you 5 years on the RICO. People have gotten 10 years. Samuel Bull, I think, got 10 years for RICO. So RICO, that fluctuates. You can get up to a year, up to life in prison. But but when it comes to sex trafficking, it's a 15-year minimum to life in prison. So if they catch him with one of them, Cassie, I think that could be a guilty. And and the other one, her name was Jane Doe. She was paid for the sex trafficking. She had a contract to do free calls. I don't think they're going to. I think she would be a not guilty for me. But if they catch him with one of the sex trafficking, he's going
to have a bad day.
He's gone. It's 15. He's gone for 15 years. And then those other prostitutes across state lines, those are all just pluses now for your sentencing. Well, you got this felon, you got now that just turn the sex trafficking to a minimum of 15 to like maybe a minimum of 20.
And it's even worse than that because the federal rules allow you to use acquitted conduct in the sentencing. So you can use, if he was found not guilty on the Jane Doe, beyond a reasonable doubt, the judge could find it by preponderance and then use it as a sentencing factor in his. Yeah, I know. That's the really rough one.
That's tough. And on top of that, hearsay and all other shit. A lot of those rules.
Yeah. It's potentially a very bad day for him. Yeah.
So if he's able to avoid both the sex trafficking charges and the RICO, that's a win for sure for Diddy. I think that's a win. But I think they got him on at least one of the sex trafficking. And then it doesn't matter for RICO. They can say not guilty for RICO. It fucking doesn't matter because you're going to jail for 15 years. And if they hang on RICO, you know what? The state can go charge it, can do it all again with a new jury. Right? So I think right now, if I'm Diddy and I'm going into that prison tonight to sleep, I'm worried.
I'd be really worried. I'd be extremely worried. Yeah. I'd be very, very worried. I think that they're probably guilty on all 4 of the counts, 2, 3, 4, and 5. And I think that because they have 8 predicates. Yeah. And I think that they're having problems coming to a unanimous conclusion as to some of the predicates. And they don't know what to do because the form as it's written requires for each of the predicate, like, do you unanimously find that it was proven or not proven? Now, like for the purposes of RICO, they only need to find 2 of the predicates.
Yeah.
But there's no way for them to like express that on the form. There's no way for them to say, well, we find these 2 beyond a reasonable doubt that they're proven, and we don't have an opinion as to other ones. We don't know. There's no way for them to express that.
You know what? I think you may be mistaken is because if you say they found them guilty on the first 4 charges, those first 4 are RICO predicates in themselves.
No, I understand that.
So if you find them guilty on the RICO predicates, then RICO's a gimme.
I understand that too, but the problem is that on the verdict form, it asks them for each of the predicates. There's 8 predicates, and asks them for each of them, has the predicate been proven or not proven? So if they find the trafficking and the distribution, then presumably they would check proven as to those 2 on them, right? Okay, now there's still 6 remaining. There's 6 remaining.
You can say no to those. You can say no to all of those, and you still get RICO.
I understand that, but they might have to. They think that they have to come to a unanimous conclusion as to yes or no for each of the predicates. So what do they do if they've established to their own satisfaction 2 of the predicates are true? Okay. So we think they're proven. And as to, like, say the kidnapping charge, let's say they're hung on the kidnapping charge. Okay. The kidnapping one. All right. We don't know what to do about the kidnapping. We can't decide.
We don't know.
So they could return a verdict of guilty on the RICO, but there's no way for them to because it requires them to check each of the predicates. There's no way for them to say, well, we've found 2 and we're good.
We're done.
So it doesn't really allow for that. So
those are bad instructions. Then those are bad instructions because if you're right, if they find them guilty on the first 4, then I don't even know why there's a discussion on the RICO because you got them right. Matter of fact, RICO is so bad. A lot of people don't realize it. They could have found them on the 2 prostitution charges, and that's enough to give you RICO. Because it doesn't have to be 2 separate. It can be two of the same counts. You did this 2 times within that 10 years.
Yeah, but actually, the way that the verdict form doesn't allow for that either. Because the instructions, you're right. The instructions say that you need 2 offenses, and it doesn't matter whether they're in the same category. So you could have 2. Yeah. You could have 2. I'll show you the verdict form, but it just asks for each predicate. It lumps them all together. So it just says, do you find like any version of kidnapping that's proven? Yes. Now you only need 1, but there's no way for you on the form to say, I find more than 1. You just says, do you find it? Basically, it says, do you find at least 1? I'll pull the verdict form. I'll show you. I'll show you the problem.
That's a bad verdict form, because you could technically find 2 of the transportation for prostitution, and that gives you your RICO predicates, or 2 of the sex trafficking, if you're saying it, and that gives you your so the verdict form. If they lose, the prosecution loses, that's because they messed up on the verdict form.
Yeah, no, I'll show you exactly the problem. Okay, because I'm here to prove things and educate.
Yeah, of course. I still want to see it.
Yeah, give me a second to. All right, no, that's not the wrong one. Okay, this one. Yeah, okay. So here's the verdict form in all of its glory, and I'll show you exactly what the problem is. Right. So it's like, okay, as to count 1, how do you find the defendant guilty or not guilty? And so let's say, okay, in order for them to find guilty, they need to find any 2 of them, yes. Right? But it says, if and only if, what types of racketeering activity do you find were involved? And it just says acts involving kidnapping. Okay. It just says acts involving sex trafficking. So like the way this is written, right? Suppose they find, because there are two counts of 2 different sex traffickings, and that should be sufficient for RICO.
Yes.
But there's only like 1 box for them to check.
Yes.
So, but they can't. So it's like all the acts have been clumped together.
Yeah. Yeah. So this puts the prosecution at a huge disadvantage.
Yeah.
At a huge disadvantage. And the fact that RICO's first puts them in a huge disadvantage, because they should have had the sex trafficking and the prostitution first, and then sex, and then you kind of conclude with RICO saying, hey, if you found guilty on the first 2, then these will automatically be checked and automatically, you know what I'm saying? Because
well, that at that point, that was just, I think they're literally just listed in the order in which the indictment listed them, which of course was a completely arbitrary choice. The government could have listed them in any order it wanted.
Yeah.
But it chose this order, and so they're stuck with it because it's the same order in the indictment.
Yeah, they screwed themselves.
So if they were thinking ahead, they should have written it differently, so they would have that now, and now they're hosed. So yeah, the way it's written, it's like, and you see what I'm saying about you see what I'm saying about the 8 predicates, because it's like, well, it's like, what do we do if we find, let's say we find the sex trafficking and we find the distribution, okay? Because those are the 2 predicates.
Those are 2 predicates.
So we find the sex trafficking proved, we find drug distribution proved. All right, now let's say that, we're going through the rest of them, and we come to acts involving kidnapping. Let's say that we can't we can't decide. We can't come 12-0 whether it's proved or not proved. So we found 2 predicates, but we can't come to a decision on kidnapping. So what do we do in that situation? Because this form doesn't have a we don't know button. The way the form is written, it seems to require the jury, and I'd interpret it as requiring me to have unanimous as to each 8 predicates, even though I only need 2. It's like, but it requires me to have. So what do I do if I'm hung on like the kidnapping charge? I find all 7 have been proven, but I'm still hung on the kidnapping charge. What do I do now? The form doesn't really allow me to express that, and so I'm just kind of stuck.
Yeah, yeah.
So the form has problems, Nate. Yeah, the form has issues. Form has issues.
It's good for the defendant. The form is very, very good for the defendant. The defendant is definitely blessed by a bad form, because they should have started with the predicates first and then wrapped them all. Well, if you found part 1 already proven and this one proven, then those are 2 predicate. Then then check prove down below, like something like that. So it all just kind of flows together.
Yeah.
But right now, I think you're right. I think if I was the betting man, I would say he's guilty on the first
2, 3, 4, and 5.
I would say, yeah, I would say, except for the J, like there's 1 sex trafficking. I can see it being not guilty.
Sure. Okay. Fair enough.
I can see one of the sex trafficking it being not guilty, but the other one, and I think the Cassie one is probably going to be a guilty, because they asked earlier in the day, the jury came back and asked, a question. The question was to look at some testimony from Cassie, but it was the specific testimony they wanted to see. And that specific testimony was they were at, I think, a film festival, and it was clear that Cassie had said, no, she did not want to do a freak off on a certain day, right? No, I don't want to do a freak off. Then all the witnesses said that, that Diddy showed her his video on her phone of her involved in freak off. I was like, I'm going to let this out if you don't do the freak off on Monday. That's the coercion. Then they go to the other place. They go to land, and then she participates in a freak off. She says, I didn't want to do that. So that was the clearest, like, hey, here are all the elements of sex trafficking. We want to hear that again. So that's why I think they're probably a yes for Cassie. And then the second one, I think they're definitely a go for the other two. They asked earlier for the prostitutes, the 2 male prostitutes. They asked for their testimony to be given back. Now, and the reason why is because the defense was making a thing that, hey, they weren't escorts. They weren't prostitutes. But the guy in his testimony said, I went there to have sex for money. My job is to have sex for money. So that seems
that's a great job. How do I get that job? Is that on Glassdoor or LinkedIn or what? How do you apply for the I have sex for money job?
Yeah, that's what he said. I have sex for money. So if you're having sex for money, then guess what? We're at that next level. So I that's why I think the first 4 are probably that. But again, everybody's so focused in on RICO, but nobody really understands,
because RICO is a confusing bitch.
Yeah, but RICO is not the one he's most afraid of. It's got to be the sex trafficking. Sex trafficking is the one. And one thing too is it does also show you a lot of I was watching, I think it was TMZ or something, where they were where they had the attorney come on. He's like, oh, this is so unusual for them to use RICO, this. And I'm like, what are you talking about? R. Kelly, you know what they convicted him of?
RICO?
Oh, yes, RICO. And sex trafficking. Harvey Weinstein.
A little bit of RICO?
Yeah, there was a little RICO in there. Donald J. Trump.
Well, that was state law, but
state law. But what was it? What charges were they hitting them with? They happened to be YSL. I'm like, this happens. RICO is something they use all the time. This isn't unique for the Diddy case. So, but I think that's one great thing that the defense did, was able to make it seem like this is so foreign. This is only used for the mob. This is only used in unique situations. This is such a weird situation to use RICO when R. Kelly is in jail now because of RICO, because of federal RICO. So it just is what it is,
Yeah. And RICO can be, and there's, I forget how many total predicate acts there are under RICO categories. It's like 40 predicate acts. It's a long list.
Well, in this trial,
I mean, there's 8 here, but I mean, in the statute itself.
No, there's not 8. The 8 are the categories, but there are something like,
that's true.
30 different crimes for kidnapping. Even though they removed the attempted, there was conspiracy to kidnap, aiding and abetting kidnapping, and it was also attempted kidnapping, which they removed. So for each one of those levels, there were 5 underlying, like the aiding and abetting, the conspiracy to, and the attempt to. So you're talking about multiplying each one of them by 4, you're done, You're done. So they were hitting them for every which way. And they removed it 2, that was when everybody was saying they dropped the charges, but they didn't drop any charges. They removed the attempted because all the testimony said it was completed kidnapping. It was a completed arson. There was a fire in the car, and the kidnapping, the woman was actually taken. It wasn't an attempt. So they removed the attempted. But yeah, he was charged with 30 different charges. So, but again, I think RICO is just confusing. But I don't know. What do you think about the jury going home tonight? Because I don't know if you heard earlier, the jury, the note the jury gave is that they're horribly dead. In other words, they're horribly deadlocked. Everybody's dug into their positions on RICO, either guilty or not guilty. So they don't believe they can change. Do you think minds will be changed going in tomorrow?
Probably not. I would have been very strongly tempted as the judge to take the partial verdicts. In fact, I almost certainly would have, to be honest. I would take the partial verdicts on 2, 3, 4, and 5. And perhaps give them an Allen charge on count 1 and send them back on count 1 and see where that goes. But I'll take the partial verdicts on 2, 3, 4, and 5.
Yeah.
Move on. I'll enter them in the record. That's fine.
Yeah. And it's interesting because Would you be shocked if they found him not guilty on the 4 counts, 2, 3, 4, and 5?
I'd be surprised as to the distribution. I don't think I'd necessarily be surprised as to the trafficking.
Trafficking, I wouldn't be surprised. I'd be surprised well, and also drug distribution. I don't see how that's not a gimme. I think the RICO problem is not a problem with the predicates. I think it's a problem with the organization. I think I think they believe the argument that this was personal, because that's another element for the RICO, right? It's got to be a corrupt organization. And I think they've made the argument that that this was all personal. So if you make the argument this is all personal, then you don't really then you kind of remove that corrupt organization aspect of it. And that's what they kept hammering. This is personal drugs, personal girlfriends, right? So this is not RICO. This was him doing it on himself. So I think that's what they used to confirm the RICO charge.
Rubbish. It's like, as long as you've got 2 or more people engaged in a common enterprise, which is basically a common purpose. If the purpose of the enterprise is to feed his needs, that's a common purpose. And as long as you're doing illegal things towards that end, you're there.
That's the better argument. But the argument they were making was Combs Industries, blah, blah, blah. These companies were the corrupt organization, and he happened to be the head of these companies. Now, I think the argument should have been this, like what you're saying, it's a kind of a fictitious company, but he was using these other companies as essentially subsidiaries to fulfill his needs in the way you just said. Yeah, but they didn't do that. They were like these companies. So now I think that's the argument. Was it the companies or was it for himself? So, but we'll see. Well, are you doing Verdict Watch tomorrow?
I don't know. Probably not. Incidentally, by the way, I think a lot of people know, and we haven't talked about it yet, that your wife was ill recently because you had mentioned it on Twitter and stuff. And so I thought maybe you could update the chat for those of you who don't know how things are going in that domain.
Oh, things are going. Well, my wife just recently had the surgery, and I spoke about it on my chat recently. Just before I got out. Everything went well. We had surgery, and things went really, really well. So she's recovering now. But I haven't put out content in a while because it's just you got to be kind of mentally in a place to do that.
Yeah.
So it's been difficult because this energy. When you're doing these videos, right? There's an energy, there's a vibe, and I just didn't have it. But now I'm kind of getting back to the flow because we've had a positive outcome right now. So we'll see. But she's doing fine. Everything's doing fine. We're still in the recovery phase, and we're going to we're about to head into radiation. So hopefully things will be, that'll be the end of it. So, but it's funny because what's Mike Tyson says it. Everyone has a plan till you get punched in the face.
Fair.
Cancer punches you in the face, so now it's kind of like, all plans went to hell and now we're trying to figure this out.
Well, fortunately they caught it extremely early. You said stage 0. I didn't even know there was a stage 0. So I was like, oh, okay. I was like, so that's like, that was pretty encouraging. So I'm like, okay, great. So great on being able to diagnose that. That's awesome.
But the sad part about it is this, that no one ever wants to hear you have cancer.
No, but if you're going to tell me you have cancer, that's like the next word's to stage 0. I was like, okay, that's better. That's better news.
That's best. Yeah. So, but let me get out of here and take my daughter to her tutoring class. But listen, man, thank you so much for inviting me on, and I'll be talking to you a little later, man.
Oh yeah, and you heard that Koberger is doing a plea deal, right?
Yeah, I heard about that.
Apparently, it's going to be televised tomorrow morning. So if you want to join me for that, if you want to join me tomorrow morning, you're welcome.
Okay, cool.
I'll let you go. All right, bye-bye.
All right, later, bro.
Bye. All right, cool. That was Nathan Lawyer. We love Nathan Lawyer. He's great. Yeah. Yeah. So if you're going to get bad news, I suppose that's the best version of bad news, right? It's like, well, you have cancer, but stage 0 cancer, so it's not so bad. It's like, okay, that's good news. So excellent. Yeah. Love your content. Thank you. Let me check what's going on in Discord because I think someone said they sent me a link or something. Okay. All right. Someone wants me to do the Donald Adelson case related to the murder of Diane Markle. I might do that. Yeah, Donald Adelson charged with orchestrating a murder for hire, facing first-degree murder, conspiracy, solicitation. Jury selection starts August 19th. Trial runs through the summer. Very cool. Very cool. Maybe I'll do that one. Let's see what's going on. Yeah, so Koberger we'll cover tomorrow when it happens. I'm looking forward to that. That should be good. I need to check something. Hold on one second. What I think of the plea deal? Well, I'm very salty that apparently it comes with just the minimum required allocution. I'm salty that it does not include a full fat allocution. I'm a little salty about that. I'm not going to lie. I need to go to Walmart soon because I need to pick up some stuff. Pharmacy closes in an hour, so I need to go at some point pretty soon so I can do that. Let's see what else is going on. I might just sign off real fast so I can go to okay. Partial verdicts in New York. Yeah. Well, yeah, but you cited a New York case and this is federal. So yeah. Someone in my chat said, I found this about partial verdicts in New York. And then they say NewYorkCourts.gov. I'm like, yeah, no, that's not going to help us because we're not in a New York court, right? The court might be in New York, but it's not a New York court, right? Because it's federal, baby. It's federal. So yeah, that's fun. Yeah, so I'm a little salty that apparently it just comes with the bare legal minimum allocution, which I don't know what that is in the state, but just the bare minimum, like admitting to the elements of the crime, probably. I'm salty that now the judge, incidentally, by the way, still could insist on more, but the plea deal itself doesn't require more. Now, if the judge has judge balls, the judge could say, no, unless you give me a full allocation. I don't have to accept your plea to guilty. You can't actually plead guilty unless I let you. You can't plead guilty unless I let you plead guilty. And I've heard of it happening in cases from time to time, but it's pretty rare. But I've heard of defendants in like minor cases, obviously, relatively minor cases. But I've heard of defendants who are like, we're pleading guilty. And the judge is like, no, how about I just dismiss the case completely? How about instead of guilty, how about dismissal? Because this case blows chunks. I've heard of that happening. But yeah, it's like you can't plead guilty unless I let you plead guilty. So yeah, if the judge had judge balls, the judge would be like, yeah, we're not doing this unless you do a full and complete, unequivocal, full-throated allocution in details about exactly what you did. And if you hesitate or try to, avoid responsibility or something, then I'm not going to accept the deal either. So take the stand, get under oath, put them on the stand, and tell us everything. Tell us all the things. And keep talking until you make me happy. So the judge could do that if the judge has judge balls. I really hope the judge will do that, but he probably won't. He probably won't have judge balls, which is sad. But I hope. One can hope. One can hope the judge has judge balls. So we'll see. Yeah. Yeah. Like you can't. It's like I'm not accepting a plea of guilty unless it comes with a full allocution. Fuck you. We can go to trial. It's like we could go to trial, and the state can prove everything, and that'll bring everything out. Or you can just allocute. Either way, it's like we're going to know the story. It's like I need to know the story. So no plea deals. Not even a plea deal. Just a plea, right? If he wanted to just plea guilty. Forget a deal. He wanted to plead without a deal. Judge could be like, nah. You know, obviously in the interest of justice, you know, so the judge wouldn't do it flippantly, but it just can be like, nah, I'm not accepting your plea. Fuck you. Yeah. Do we have a time? It's like 10 in the morning tomorrow or something like that. I think the time is known. Oh, it might be 10 local time. So it might be 9 my time, which would be 8 the East Coast. So let's see if we can find a precise time for this. Apparently, on Polymarket, incidentally, for Diddy to be found guilty of sex trafficking, Polymarket is currently betting 90%. I think Polymarket has it about right. I think they might be underpricing it, to be honest, but yeah, I think they've got it basically right. I wouldn't wish on anyone to know the graphic details just because we want to hear them. No, I think we as a public have a right to know. And this is a government of the people in the end. This is a government of the people. And I think the people have the right to know what happened. I think it's in the interest of justice that people know what happened. So put me in as judge and I'll turn down the plea. Put me in, coach. I'm ready to go. Because I have judge balls. All right, what am I trying to do? I was trying to find what time the plea is tomorrow. The BK judge has pretty low tolerance for BS. I can only hope he has some judge balls. I mean, I would do it like right away. Like this is how I would play this, right? They all come in. I'd ask the prosecutor, prosecutor, my understanding is that there's a plea deal and this plea deal has been reduced to writing. Okay, let me just save everyone some time. Unless there's a full and complete allocution of the crime in detail by the defendant, I'm not accepting this plea. So what do you want to do? I mean, the prosecutor probably doesn't oppose it. I mean, I don't know why they would. The defense might be like, we don't want to do that. I'm like, okay, well, you can either give me the full and complete allocution or you can withdraw your plea. Which do you want to do? And if he wants to withdraw his plea, it's like, okay, we'll go forward. Fuck you. We'll go forward. Fuck you. And, you know, if by some miracle or not, the state fails to prove its case and the jury finds not guilty because the state failed to prove its case, well, then justice was even more served because apparently the state didn't have the case at all anyway. So, you know, it's like if in the end the jury found not guilty because the state failed to prove it, then I achieved the ends of justice even more so because an innocent person didn't go to prison. That's nice. So it's all good. It's all good. $11 a.m. their time. So that's 10 a.m. my time. All right. So we'll be on 10 o'clock tomorrow. Do federal judges have a quit time? I mean, not officially, but, you know, they wrap up the day usually around 5 like everyone else does. But, you know, they don't really have an official quit time. Judges can kind of do what they want. It's like, you know, so they usually work like a 9 to 5, pretty much like most people. So, but, you know, they don't have an official. Yeah. So. Mm-hmm. Here's apparently someone doing a little insurance fraud and then got sad when they realized there was a camera who witnessed the whole thing. So I'd like to watch this, even though it's not particularly related to anything, because I'd like to see some guy who has bad thoughts in their head get just destroyed. So I'd like to watch this video for a minute. All right, let's watch this thing.
One hand on the. What the? Oh my god!
What happened, babe?
Oh my God, what is he doing? Babe.
That would be the insurance fraud, right? That's pretty insurance fraudy. Yeah.
Hey, what happened?
Oh shit. I don't know.
Babe.
I got into an accident. Oh my God. Oh my God.
Where are you?
I'm on the Bell Parkway. This guy just reversed into me. What the hell is going on?
Reversed into you?
Yeah. Oh my God. Oh, fuck, I'm shaking.
My God. Babe.
Yeah.
Just stay there. Oh my God.
Fuck, oh my God.
We're on the Bell Parkway.
Yeah, see, they're all pretending to be hurt and injured. Yeah.
Holy shit, you know, after that turn?
Yeah.
Fuck. Oh my
Babe,
God.
it's okay.
They're gonna figure it out real fast. They're gonna figure it out.
Fuck.
They're gonna figure it out in a second.
What happened? Hold on, babe. Oh, fuck.
Yeah, they figured it out.
Wait.
I think that they're taking photographs. Yeah, I think they figured it out. The guy figured it out. He saw the thing. It's like, oh yeah. So he figured it out. Yeah, exciting. So all those people can be charged with offenses, right? Those people can be charged with offenses because they're clearly involved in a conspiracy. I mean, the actions clearly demonstrate a conspiracy. They are at least attempting insurance fraud. They're also engaging in reckless conduct. So that's reckless conduct and insurance fraud and battery, probably aggravated battery because we're using a car. And we'll see what else I can dream up, when I, start thinking about how to prosecute the case. But it's not going to end well for these guys. So, yeah. And then apparently they were in fact charged. So here apparently is a press release relating to this. This is apparently from 2024, but yeah, they were charged. Brooklyn man charged with staging car crash on Beltway. Queens District Attorney Melinda Katz announced that Michael Martinez was charged with staging a motor vehicle accident, reckless endangerment, and other crimes. You think? After being in a car that allegedly caught another driver, forcing driver stop, the car defendant was then reversed into the victim's car. It sure was. The DA stated the defendant and others allegedly staged a crash on a busy highway and rammed an unsuspecting driver when the vehicle, after they forcibly stopped her in the left lane. Countless lives were put in jeopardy to this reckless conduct. You think? The investigation is very much ongoing. I encourage anyone that suspects they may have been a victim of a staged car crash to call the police. Martinez, 28, was arraigned last night on charges of staging a motor vehicle accident in the second degree, criminal mischief in the third degree, reckless endangerment in the first degree, conspiracy in the fifth degree, and insurance fraud in the fifth degree. Yeah, I mean, I think you should throw in an aggravated battery on top of it too, to be honest. But that's a good list. The criminal judge ordered him returned to court on the 7th. If convicted, he faces 2 1/3 to 7 years in prison. They really should charge the battery. They should charge the battery with a deadly weapon. Aggravated assault with a deadly weapon. They should charge that. According to charges, on October 16, 2024, at approximately 11 in the morning, Aspician Natasha was driving north and left lane on the Belt Parkway near the Nassau County border. The woman's vehicle was equipped with both front and rear dash cameras. At the time, a silver Honda Civic confronted the vehicle and came to a stop. The victim was forced to step on her brakes to avoid the collision. The Honda then quickly backed into Natasha's vehicle, damaging both her car and the Honda. The occupants of the Honda held up what appeared to be a plastic tarp in the rear window of the car that partially obstructed the victim's driver's view inside the Honda, and the occupants of the vehicle switched their seating arrangement within the Honda. Neat. After a collision, 4 people exited the car, including a woman who got on the driver's side, and a man who identified himself as Michael Martinez, and said the purported driver was his wife. Another woman and a man who exited the vehicle are presently identified. The footage surrounding the crash shows a red Kia Sport following the car. After the crash, the Kia stopped in front of the Honda, and the 4th occupant of the Honda exited the car and entered the Kia, which then left the scene. Nice, they had a getaway car. Martinez was operated Thursday after arriving in a New York flight from Ecuador. The investigation's ongoing. Very exciting, very exciting. So a little light insurance fraud. They should have charged the aggravated assault. They really should have charged the aggravated assault, but otherwise, that's good. And incidentally, they should charge everybody because he should absolutely charge everyone in that car with conspiracy. I would charge them all with conspiracy and see which of the little rats, right? See which of the little rats wants to flip first. Charge them all with conspiracy, and whichever one of you little rats flips first gets off to prove the conspiracy. You know? So yeah, that's a trick that was missed. But other than that, I'm fine with all those things. So that's exciting. How much are dash cams? Not expensive particularly. $100. More expensive if they not particularly expensive. They don't necessarily work particularly great at night, but during the daytime they tend to work pretty well. So, yeah. She should sue them civilly? Of course, 100%. She can sue them civilly for battery. Battery, negligence. Intentional infliction of emotional distress would be good. Negligent infliction of emotional distress, that'd be good. What else? Yeah. Vehicular assault? Sure. Yeah. Obstructing the flow of traffic just to be petty? Nice. Yeah, well, you want to also charge them for the traffic violations? That's cute. You want to charge them for the traffic infractions on top of it too? Very, very good. Yeah, we'll charge them for the traffic infractions as well. That's great. All right, I'm going to go ahead and go to the store so I can get my stuff. Loss of income? Sure. If there was loss of income, medical bills, the cost of the repairs. Yeah, all this stuff. Property damage crimes. Trespass to chattel as a tort. Trespass to chattel, that'll work. Yeah. Videos like this make me think getting a dash cam would be good, but then I worry it could be used against me. Do I have an opinion? I don't know that I have an opinion on that question. That's interesting. I've never really thought about it. Yeah. All right, I'm going to go ahead and go because I need to run to the store. I love you all. I've been on civil law. I will see you tomorrow at 10, my time, for a little plea deal discussion for whatever value it has. And for the moment, that brings us to the end of discussion of all those cases.